Well, I have Mark Polden with me here. Mark's a barrister and he's been an in-house counsel for Fairfax for a couple of decades before he's gone to the bar. And he is the co-author of The Journalist's Guide to Media Law. Welcome, Mark.
Thanks, Mark.
Today we're looking at defamation defences. And really, given the interests of time, I prefer just to focus on the three main defences that journalists would work to without engaging lawyers normally. And they would be the truth defence, the defence of a fair and accurate report of court or parliament, and the defence of honest opinion or fair comment. So would you mind explaining in lay terms just the basic elements of the truth defence?
The truth defence is very straightforward. Really all one needs to prove is that the material published was substantially true. It doesn't have to be 100% accurate. Substantial truth is enough. The difficulty, so far as there is one, is this. The statutory defence set out in the Defamation Act 2005 in each respective jurisdiction provides that the defence needs to be pleaded to the imputation, and we'll come back to imputation in a moment, which is a term of art. It's not enough to prove that the material, the actual word for word, is all true. You have to also be able to prove that any inferences which get drawn from that are also true. And that's where the difficulty can arise. And it can arise also in this way, that you may need to prove not only literally the words in your publication true, but the meaning which is arrived at by somebody who reads that material knowing some other facts, which are called extrinsic facts, facts outside of the material. I'll give you an example. Many years ago, there was a car crash on the south coast, and there was a broadcast on the news in the evening, and it said something like this: little did rescuers know the man had AIDS. And as those words were being said, the camera focused on the person in one of the cars. That person sued, and he complained about a number of defamatory meanings. One of them that he complained about was, he said, based on knowledge that people generally had at the time, it was 30 years ago, that if he had AIDS, it was likely that he was either an IV drug user or likely that he was a homosexual. And in cases since that, say, juries have decided it's not defamatory to say, for example, that somebody's gay. But he said that people in the reception area also knew that he was the pastor of a fundamentalist Christian church. So what was the meaning you got to? If he was living a lie and he was gay, people knew that he put it about that he was married and that he looked with disfavour upon people of different sexual orientations. So what was the meaning that had to be defended as true? He was a hypocrite. He was a whited sepulchre. He was a person who pretended to be something he wasn't. So it wasn't simply enough to prove that he was in the car. As it turned out, they got the wrong person. It was the other person in the other car who...
Which made it even harder, I guess.
Made it impossible.
I think the lesson there is that we need to prove the meaning that's coming from what we publish and not just the literal fact of what we publish itself. Yeah.
Precisely so.
Yeah. Moving on to the defence of fair and accurate report of court or parliament. What's important there for, say, a court reporter wanting to win this defence if they're covering a court case?
Again, it's really not that difficult, and it's the mainstay defence. It's the most useful and frequently used defence for newspapers, and usually it works. The most important thing is to make sure that what you're publishing is a substantially accurate report. That is, it's a report that could have come from the pen of an average bystander there in court. It doesn't have to be accurate in the sense that it came from the pen of the lawyer, but it mustn't leave out half the story. For example, it's not going to be a fair report if, under deadline pressure, a court roundsperson attends court until the morning tea adjournment, then leaves and doesn't cover the other half of the case. The other thing that's very, very important is to make sure that what you're reporting in fact happened in open court. And sometimes people will try to take advantage of the fair report defence by, for example, publishing extracts from court documents that they've been provided with and that somebody has told them are open to be reported upon. The mere fact something's got a court stamp on it doesn't mean necessarily that you're entitled to do a fair report of it. You have to make sure either that it was tendered in court, it was handed up in open court, or read, or taken as read, or in some jurisdictions that it's available on a file which is accessible to the public. And it's really important to get that clarity around documents. The one that I have seen go wrong is the police so-called fact sheet that a journalist is told after the event by the police, the journalist not having been there, look, you can report this is what was handed up, and it turns out it wasn't. And if that happens, there's no protection for that report.
Well, thanks. And just moving quickly to the third area, the third defence we can talk about today, this honest opinion or fair comment as a defence. There's so much opinion out there in the media today. How do they defend a defamatory opinion?
Well, it's a very, very useful defence. The most important thing to be aware of is that one needs to separate out fact and comment, and any good journalism teacher or editor will tell you that that's important anyway. The most important elements of that defence are that what is said is an expression of opinion, not statement of fact, and that's a notoriously slippery category, and it is not something which is easily determined by writing something necessarily on an opinion page. It could still be a statement of fact, but let's assume you get past the first hurdle and it appears that, to be a statement of opinion. You have to ensure that your opinion is based on facts which are either set out or adequately referred to in the material. You also have to make sure that the facts, so far as they're set out, are accurate, and that is usually where the comment defence comes unstuck, on a matter of an error in what's called the substratum of fact, the underlying factual matrix on which the comment is based. I mean, the notion of the defence of fair comment is that one can express an opinion based on facts, and then the reader can look at the facts, and it's up to him or her to decide whether they agree or disagree with the opinion, so that if the facts aren't accurately stated, it undercuts the whole basis for the defence. The other thing that needs to be borne in mind is that there is also an issue of what's called congruence, which is, as the journalist, you really need to be in a position to foresee the defamatory meaning that's going to be conveyed and have an honestly held belief in it. And that can be quite tricky, because when the proceedings are subsequently initiated in court, a very expensive and very adept QC will then draft out your opinion for you and endeavour to convince the jury that that's what the article actually meant. And then you will be asked, and you will have to tell the truth about this. Did you honestly believe that whatever the statement is at the time you wrote the article? And that's a trap. So one really needs to think very, 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 very carefully about what opinion is being expressed. I'll give you a very quick example. Meskinas and Capon. Meskinas was a painter. Edmund Capon at the time was the director of the Archaeology of New South Wales. He was quoted in a newspaper as saying of a picture that had been drawn or painted by Mr. Meskinas. It was a portrait of the late stockbroker Rennie Rivkin. Oh, look, it looks like the neck's been painted out of it looks like it's been painted out of chewing gum. Look at that. And when I saw it, I just went, yuck. That was the sense of what he said. And he was cross-examined on the question of honestly held belief. And he admitted that his belief was that it was a bad painting. Mr. Mosquinas had convinced the jury that what it conveyed was that he was an incompetent painter. And Mr. Capon disavowed any belief in or suggestion that he was saying anything about or intended to say anything about the painter or held any belief one way or the other about Mr. Mosquinas being an incompetent painter. He said that all he was thinking about was the painting itself. So that was an example of of a case in which the honestly held belief, bad painting, didn't match the defamatory meaning, incompetent painter.
Well, thanks, Mark, for explaining those three defences. Clearly, with the last one, as with any journalism, it comes down to using very precise language to get your meaning across. Look, thanks so much for your time today and spending a few minutes with Journal.
Absolutely, pleasure. See you.